you ever threatened any manager or boxer or promoter for not carrying out any wishes? I respectfully decline to answer a question on the ground that I cannot be compelled to be a witness against myself.
That, ladies and gentlemen, is precisely what invoking Fifth Amendment right to not engage in self-confession or admission. That is what it sounds like. That is a recording of one of the men who managed a boxer back in the days, and it began to question him regarding some of his activities as to whether it was right or wrong. And that specific moment of that video that you just watched was the turning point of that entire case, through that simple utterance of the basic substantive right that is affirmed in the Fifth Amendment. This exists on a state level also. Trials for crime, compensation for private property taken for public use. The first clause acts as the entryway to which the other clauses can be joined to. Remember, legalese is like math. You can add, subtract, divide, or multiply. And it goes on to say, no person shall be held to answer for a capital or otherwise infamous crime, nor shall be compelled in any criminal case to be a witness against himself. Why does this exist? Why does this clause exist? The answer to that question is right after it. The next clause. Nor shall be deprived life, liberty, or property without due process of law. The principle as to why self-confession or self-admission against yourself, aka being a witness against yourself, whenever you say something against yourself, those words are admissible according to the hearsay rule based on declaration. In the past, we went over that in several videos, both on a state level, rules of evidence, and a federal, aka the uniform, rule of evidence. Just to refresh the memory, here's the reference. Rule 801, 802, and 803. Exclusions from hearsay, meaning these are the things that are not considered hearsay. Statement. Quote, statement means a person's oral assertion, written assertion, or nonverbal conduct, in this case, being a witness against yourself, either written, oral, or nonverbal. Declarant means the person who made the statement. What type of statements, which we just described as being something that could be oral, written, or nonverbal. So what type of oral, written, or nonverbal assertions are not hearsay? In other words, it is excluded. In other words, it is admissible. If it is excluded as in hearsay, that means it is admissible. Statements that are not hearsay, statements that are admissible. Remember, we're on the note of being a witness against yourself in the different ways when it comes to proceedings on a judicial or quasi-judicial level, that witness statements, that one can become a witness to a matter and enter into any given record. Their assertion is through a statement, whether oral, written, or nonverbal. And based on how evidence, which is a law of its own, how it's admitted, witness statements is one of the things that are used as evidence. Evidence are governed by certain law. The operation of that law of evidence is on a uniform level called Federal Rules of Evidence. What is hearsay? Hearsay is when a party, it does not discern whether it's a third party or whether it's the supposed plaintiff or the supposed defendant. It just says a party, so long as one is properly joined into the case, whether as an intervener, whether as a first party, second party, or third party. However, anybody within the given instant matter. A party offers an evidence to prove the truth of the matter asserted in the statement. In other words, whenever anyone says something, it can be considered an hearsay, or the declarant does not make, or hearsay can be a statement that the declarant does not make while testifying at the occurring trial or hearing. So you see that the rule of evidence itself actually gives you the definition of hearsay. Most people's concept of what they think an hearsay is, it's not actually what it is. A hearsay can be a third party's statement, if you can qualify it as such. But really, hearsay is just a statement made by someone while they're not testifying. That someone can be a third party, fourth party, or a first party. Or it can be anything that is presented, aka offered, with the intent of saying this is the truth of the matter. In other words, anything anyone say is automatically categorized as a hearsay. Hearsay is not just limited to the concept of having first-hand knowledge and experience. That matters also. That is not the limits of what hearsays are. Statements are anything that's oral, written, or some type of gesture, nonverbal. That is why your nonverbal communication cues are extremely important in courts also. This is where signs and symbols play a huge role, because those can be used to send messages that are admissible. Pay attention. We'll go over that in the future. But what we're looking for is 803, exceptions to the rule against hearsay. Whenever someone asks you anything, in most cases, it's usually something about your recollection. The instance we just played at the beginning of the video, they asked him a question that requires him to recollect it in his mind and give a response. Whether one realizes it or not, the moment a question and answer circumstance is invoked, something like an interrogatory. Interrogatory is basically a question and answer that's implemented into the pre-trial process as a form of discovery. It can be evoked after it, but under very fixed condition. But usually, in most of the case, interrogatories are part of the discovery process. And the exceptions to where it's not limited to discovery is during deposition of witness stands. Not depositions done outside of courts, but deposition during trial. Depositions can still be evoked one way or the other during trial. And when you take that stand, someone starts asking you a question, they are interrogating you. And those questions, and all questions, no matter what form they take, verbal, written, or nonverbal, require some recollection or activity of the mind to recall some information. Exceptions against hearsay: recorded recollection, a record that is on matter a matter the witness once knew, meaning you yourself can be called as a witness against your own situation. Is on a matter the witness once knew about, but now cannot recall well enough to testify fully and accurately. Was made or adopted by the witness when the matter was fresh in the witness memory and accurately reflects the witness's knowledge. This two is what we're looking for. The statement is offered against an opposing party. When you see this word opposing party, this is not the defendant if you're the plaintiff, and this is not the plaintiff if you're the defendant. Again, when you see this term, opposing party, it doesn't specify specifically plaintiff or defendant, it just says opposing party. To say that you are given witness statements against yourself, no person shall be compelled in any criminal case to be a witness against himself. This term against is the exact same thing as to oppose. This term within the Constitution, no person shall be compelled in any criminal case to be a witness against himself. This word against and this word opposing party is the exact same thing being made reference to in Rule 802(d)(2 in the Fifth Amendment, third clause. No person shall be compelled in any criminal case to be a witness against himself. Again, Rule 802(d)(2 speaks about an opposing party statement, meaning you, by your own words, you can oppose your own cause of action. This opposing party, if the intent when they created these things was to be specific to a plaintiff or defendant, then it would specify the party as defendant or plaintiff, but it does not. It's like the concept of persons when it's generally and loosely used. It's generally and loosely used. It's an open template to assert whether it's natural or artificial. Whenever the word party or qualifying terms like opposing party is used, when it comes to evidence, the rule of evidence, it applies to everybody. Otherwise, the Constitution would not have acknowledged that you can be a witness against yourself. In other words, you can oppose your own self through your own words. It is very important to stop for a moment and actually entertain the principles of persons and party. See, within this system that a lot of people go on about, specifically the ones that adjudicate matters, whether it be quasi or actual, whether you know how to evoke one or the other, whether you know how to navigate one or the other. This concept of person and party is a very fluid one. The concept of person and party is a very fluid one in that it is meant to be a placeholder. Again, the concept of party and person is just a placeholder position. This is the reason why you or any other man or woman can actually play more than one or two roles in any given instant matter. This is the reason why the concept of corporations being persons exists. This is the reason why those attorneys can be joined as parties in any given case. If you want to use that as a method of basically barring them from coming in and doing any trash, because now they're a party to the case and they cannot represent other people. But nonetheless, it seems that time has gone on for way too long where people really don't comprehend the concept of persons and parties. They know about natural and artificial. And when they see the term person, they automatically relegate it to artificial and argue on and on and on, rather than simply putting things in their place and comprehending how that fluid nature is meant to be used. The reason why you can oppose your own self in any given case, literally, meaning you are playing another role as though you are another completely different party. Say you're the plaintiff or the defendant. You can literally play another role that opposes your own concept based on self-confession and admission. The reason why that is because the quote system that a lot of people go on and rant about is a very fluid one, and it was designed to do so. This is a book about tort that explains just that. And a lot of people fail to comprehend this. This is void in people's minds. The fact that there's a fluidity in positions and party, nothing is fixed. Listen to this very carefully. The reasonably prudent person is a fictitious individual. The reason why this fictitious individual exists within this system that a lot of people go on about is because it's a placeholder. It is an open template. When a lot of people see this term person or fictitious individual, they misinterpret it based on their emotional rank and their misconditioning and their misplaced perception based on how they were conditioned when they initially got into things of this nature. This term person or fictitious individual It's just an open template of a placeholder that whoever is actually understand how to use it would actually fill in the blanks of how they want it, rather than being upset, rather than arguing, rather than staying stuck and stiff, rather than dynamic. So listen very carefully. The reasonably prudent person is a fictitious individual who has been created by the court as an objective standard, meaning it's a neutral, open template that will be filled in based on what is going on and the only thing that can determine what is going on is how competent you are. You can be as wrong as can be, but if you come right and you know what you're doing, you'll win the case. A lot of people fail to comprehend that the system that they go on about it is not encumbered upon right or wrong. It's about something called the weight of evidence. Everything in this quote system is not about whether something is right or wrong. It is not about whether you are right or wrong. It is not about whether the other party is right or wrong. It is based on the weight of the evidence. And the weight of the evidence is what you use to fill in the blank of the objective standard and fictitious individual that serves as an open template that you can fill in the blanks. The reasonably prudent person is a fictitious individual who has been created by the court as an objective standard by which to measure a defendant's action. This cautious and careful person, meaning this open template, is used to measure your act, and your act, aka your deed, can only go as far as what you know in your mind. In other words, your deeds align with how competent you are. In other words, this action that they're referring to, that they use to measure the objective standard, the fictitious individual, the measurement of that open template to be filled, how it's filled, why it's filled, and what it eventually becomes is based on your action. And your action, what you are, what you do, is highly encumbered upon what's in your mind, what you know. You can only be what you know. You can only do what you know. People act stupid because that's all they know as a reality, no matter how convinced they are about how real it is. That's all they know. So that's all they can be. And these systems that a lot of people deal with, pay very close attention to that. You can feel passionate about what is right or wrong all you want, but if you are not competent, your actions will show just that. And they will fill in the blanks of that fictitious individual, that dummy, that open template, that straw man that can be painted to be made male or woman, to be made rich or poor, one way or the other. That objective standard that acts as an open template, a blank template that could be filled in based on how they've measured you, can only go to an extent of what you know. If you don't comprehend that the term person, party, individual is an open template that can only take life and form, it can only move, it can only become, it can only compel performance, it can only afford freedom or evoke liability on the other party's end, is based on what you know. The only thing that you know is the only thing that you can bring to life through your own actions. In other words, whether you are deemed artificial or natural, typical, mundane trash a lot of people go on about and that they're stuck on, is based on what you know. And most people who are stuck on, oh, person is fictitious, artificial, and natural, I'm a flesh and blood, what you know is very limited. You're not even scratching the surface of the purpose of why that person exists, let alone how to make sure that you are not misconstrued as that which you claim that you're not. I said many times, you put things on a piece of paper saying you're doing special appearance, you're saying that you're not artificial, yet you fail to realize that that piece of paper itself still exists in the realm of fiction, and that your actions is the only thing that brings it to life. You fail to realize that, you will keep suffering. The concept of person or party is a fluid and open template that is gauged and measured based on your action, and your action can only come to life based on what you know.
You can only be what you know. And if you are incompetent, no matter how confident you are, no matter how you regurgitate over and over what you think you know, or what you think you are, or what you think you belong to, or what status you think you are, if you are not competent and you don't see the true scope of reality of what's truly going on in the quote system, you are lying to yourself and you will keep suffering. This is the reason why party and person is very fluid. This is the reason why you can actually simultaneously play two roles in any given case at the same time. This is the reason why you can bring one claim that will be admissible, and you can do other things that will act contrary to what you're saying, and it will also be admissible. Hence, you can be the opposing party despite whatever claim you're making. You can be the opposing party to your own claim. This cautious and careful person is considered to be of ordinary intelligence and to have a normal memory and normal sensory perception. This ubiquitous paragon of virtue has been humorously described by one commentator. He is an ideal, a standard, the embodiment of all qualities which are demand of good citizen. He is one, citizen, blah, blah, blah. I'm not a citizen of this, but citizen of who and what? You determine it based on your competence. Don't be stuck in the buzzwords themselves. Look at the dynamics, because the dynamics is what brings it to life. He's one who invariably looks where he is going. Most people don't look where they're going. They don't know the terrain that they're playing at. They walk into the playing field blind with false concept of what they think is right or wrong, without realizing it's based on the burden of proof, without realizing it's based on the weight of the evidence, without realizing that it's based on the level of education and competence, beyond merely how you feel or what someone else has instilled in you through emotional stimulation. To hell with how you feel. And is careful to examine the immediate foreground before he executes a leap or bound. Most people, when it comes to things of this nature, are not prudent. They're not careful. They don't look where they're going. They are careless. They are loose. And most importantly, they are incompetent. Who neither stargazes, meaning you're not delusional. Most people that do things of this nature, that say they have rights and are not guilty, are just stargazers. They're delusional. Nor is lost in a meditation when approaching trapdoors or the margin of a dock, meaning you're not speculating. You are dealing with things as they truly are. Who never mounts a moving omnibus and does not alight from any car while the train is in motion, meaning you know right from wrong, you know what's dangerous and what's not. You are competent and will inform himself of the history and the habits of a dog before administering a caress, meaning you will know the playing field that you're going into. Most people do not know the playing field that they are going into. They do not know the element, standard, and test involved in the rights that they're saying they have. They're saying, I want to sue 18 U.S.C. 241, 242, 42 U.S.C. 1983. They don't even know the elements to it. They don't know the qualifying factor to be victorious. They're saying they're doing an administrative process in order to protest. They don't know how to make that work. You're saying you're one status or the other. You're saying you're one bloodline or the other. Do you not know that if you say that you're a Moor, what makes you a Moor is not your mere claim of that title or that bloodline. What makes you a Moor, to be honest with you, what makes you a Moor is what you know. It's like putting on a fez. That fez that you have in your head is not what qualifies you as a Moor. What you know is what puts value on that fez that you put in your head. What you know and what you're capable of is what puts value in that title, Bey, El, Ali, Dey, Pasha, etc. It's not what you claim to be. It's what you know, your competency. That is what qualifies what you say you are, which includes the right that you say you have. And if you really know what person, parties, or individual truly means that you will know that it's not just limited to natural or artificial. It's based on an open template that's measured by your competency, which reflects itself outward through your actions, and will inform himself of the history and habit of a dog before administering a caress, who never from 1 year's end to another make an excessive demand upon his wife, his neighbors, his servant, his ox, his, of course this means donkey, his ass, who never swears, gambles, or loses his temper, who uses nothing except in moderation. His excellent but odious character stands like a monument in our courts of justice, vainly appealing to his own fellow citizen, meaning your own peers, to order their lives after his own example. Most people are the complete opposite of this, and thus their action shows that they're as good as a dummy that anything can be done with. So constructive trust triggers. The fact finder considers the event of the case and decides whether the defendant exhibited the due care that a person of ordinary intelligence would have. The ordinary intelligence is what they've just described to you. The majority of the people who say they have rights don't have this simple description. This simple description simply tells you, are you competent or not? Most people are not. A child is not held to as high a standard of care. It is judged against a child of like age, intelligence, and experience. On the other hand, a person who has special skills or knowledge is judged by a higher standard of care. That, ladies and gentlemen, is the importance of knowing that a person or a party or an individual is a very, very fluid principle. When you hear that word straw man, aka a dummy, that term straw man, that term dummy, it's the same thing as an open template that you can dress up, design in different ways you want. Like you see a dummy or straw man in a cornfield, but that dummy and a straw man, you can take clothes off, you can put clothes on it, you can design it, color it, whatever you want. That's exactly what a person, an individual is, at law and at equity. If you're stuck on what you think is right or wrong based on what you've heard somebody tell you that emotionally stimulates you, that you like, just so you can exercise your hate that's deep inside of you, but competence does not precede that, you are still lying to yourself. There's explanation of what a person, natural, artificial, or individual is. It's an open template that's based on your action, and your action is based on your competence. And that term person or party can simultaneously exist as a placeholder for more than one thing, whereby one man or one woman can play more than one parties, hence effectively working against themselves, hence effectively opposing their own claims, hence failing to state a claim upon which relief can be granted. The statements that we've read here can be oral, written, or nonverbal, and then further asserts that an opposing party statement, meaning your statement, the statement is offered against an opposing party and was made by the party in an individual capacity, is one the party manifested and adopted or believed to be true, was made by a person whom the party authorized. In other words, third clause of the Fifth Amendment speaks about being a witness against yourself, is reaffirmed in Rule 802 D2 when it comes to hearsay. An opposing party statement is the same thing as giving a witness statement against yourself. The only thing that was done was they just used a synonym: against, opposing. And then they left the vague term party out. They didn't signify whether it's plaintiff or defendant. They just say party. In other words, they're letting you know without letting you know that you can oppose your own self. It's said in the Constitution, and it's said herein. Your own words can be used against you. And the rule of evidence to let you know we will use it against you. Whether you realize what you're reading or not, it's your issue. The Constitution lets you know, regardless of anything, you cannot be compelled to give witness against yourself. You cannot be compelled to oppose your own intent. Why? Because when you do that, the principles of due process have been deprived from you and that whole proceeding, and defeats the intent of justice. The Constitution lets you know that you can give witness statements against yourself, and by virtue of that, be careful. Nobody can compel you to speak against yourself. This is where the concept and principle of denying comes from. This is the concept and principle of knowing that you can actually refuse to answer a question. We've all been familiar with the whole thing where people say, I don't answer a question, I don't answer a question. This is where it comes from. The right for you to not incriminate yourself. The right for you, the substantive right that's been preserved for you to not be a witness against yourself. If you're not sure, simply invoke this. Why? Because according to how evidence is admitted, your statement will be used against you. It's a very slick thing that's been put here that sits in a very easy to miss manner, because it doesn't say clearly plaintiff or defendant, but even more so because it doesn't say plaintiff or defendant, it's the reason why you ought to pay attention to it. And it says the exact same thing for those with eyes to see, just as much as the Constitution does. Beautiful people, I'm inviting you to join my Patreon page. The things we speak of over there are basically synonymous with webinars, each videos, when it comes to the quality of information and the actual aspect of it compared to the one here on YouTube. We speak about residual income and how to sue people to make residual income if you're willing to do that. We speak about tort and garnishment, remove the speculations of maritime lien. We speak about banking, express trust, all the intricacies that are important. We speak about trust related matters, different types of trust, how to actually function in commerce. We speak about the intricacies of how to actually do the W-8 ban and what makes it foreign, what tax treaties are, the stuff people won't tell you about. We speak about things of spiritual nature. We speak of child support, the intricacies of it, how it's all property right, and how cloud of legality is brought to life. Exactly how they do it and how you tackle that beyond speculation. We speak about how laws are made and how it's applicable or not, the intricacies according to the Constitution. We speak about the truth of what most people are fearful and speculative about. We go over the elements of the things that people need to know when they make claims to sue people to make money, either criminally or civil. When it comes to substantive right, we speak about the venue and the playing field that a lot of people don't know that they're stepping into. If you don't know the venue and the playing field you're stepping into, you're in for a world of hurt. We clarify misconceptions. We speak about the intricacies of things we speak here on YouTube, but more in details on Patreon. Basically, stuff that our YouTube are synonymous with things that are for the birds. One on the Patreon are the premium quality things. In the past, we went over IRS manuals in different ways when it comes to the express trust 98 number. We went over the intricacies of mortgage, land, title. We went over issues with things like driver's license and the treaties that are the solutions for it based on examples of my own first-hand knowledge and experience. Speaking about trust-related matters, more on child-related issues. We discuss other aspects of things. We discuss how to really come in as a natural person and the fact that there are actually tools that pre-exist that are meant to be used. A lot of people say, well, don't use this, don't use that. Well, do you know that same thing you're running away from is actually the solution? And do you know that's one of the ways and your first step to actually garnish it? We speak about the intricate details of discharge. We speak about things of reality that goes over people's heads. More in discharge, we speak about the functionality of spirituality and cosmology and astrology and how you can actually put it to use. We speak of the what, why, and how and importance of a foreign trustee and the resident status. We speak about spiritual things when it comes to plant, the functional aspect of it. We speak of the language of the difference in the truth of legislative fact compared to adjudicated fact and what it really means when it comes to judicial notice. We speak about the lunar mansions, how to put them to use. We speak about tort, U.S. Marshal Service. We upload documents and treaties, original certified copies.
tax evasion. We show the IRS manual that shows the difference between tax evasion and tax avoidance. We go more in about how to actually make your own pocket bigger in commerce. We show the videos and experience that I have when it comes to discharge and the explanation of it. We show elements and details. We speak of the things relating to holding people liable. Speak about the different intricacies of how these entities are used against you and how you ought to use it, and to know the playing field. A lot more that a lot of people are seeking but will not find. Again, each of these videos are synonymous to webinars of their own. We speak about how to get rid of statute of limitation. Most people's remedies, they say, are barred by statute of limitation, but there's a way out to that. We speak about how child supports are private and how and why they want to charge you thousands of dollars for some transcript, how to nip that in the butt, and a different aspect of it in great details and in great increments. Speak about the intricacies of fraud, how to prove it, the different types and the elements to it. Speak about tort. Speak about speak about trust. Speak about the subtleties of invoking equity and how to structure your document, and so on and so forth. Speak about private right, the incorporation doctrine, how people use UCC 1-103207-308, how that really doesn't actually preserve your right, contrary to the speculation that a lot of people throw around, and that your solution is actually in plain sight beyond the volatile and immutable UCC, which, by the way, the UCCs are also copyrighted. We speak about spiritual things in nature, how to use flame, and the functional aspect of beyond make-believe. I show my own first-hand experience in Chancery Court, and so on and so forth, and a lot more to come. Till next time, take care. Best of luck.